No, Mr. Collins.
Thank you, my lord. I'm going to turn very briefly to the closing submissions made on behalf of IBI, essentially the architects. I don't need to say much about these. I would just note in passing that there are two paragraphs there, particularly 6.2 and 6.4, which contain various explanations, which I take to be further efforts by Ms. White to give helpful explanation to the inquiry, and I need to say nothing more about them. They then go on in section 11 of their submission to make what are described as observations, but are perhaps suggestions for things that could be done by the inquiry. We'll find that on page 5 of their submissions. Now, I only mention these briefly. In 11.1.2, they explain that there's an English technical bulletin about updated design requirements in that jurisdiction, which is commended to the inquiry. And it may be that NSS or the like may have some comment to make on the suggestion that you should pay particular attention to that. In 11.1.3, they draw the inquiry's attention to something called the principles of the golden thread of fire and safety design in high-risk buildings introduced under the Building Safety Act 2022. Now, this is, to be fair, a new idea, at least to this inquiry. And if other CPs have anything to say on the suggestion that the Lord should pay attention to that as a helpful area of assistance, no doubt we will hear from them on that front.
Yes, as you correctly say, this, I think, reference to this English statute is the first time that we've seen it in the inquiry. Now, what I will value assistance from somebody at some stage is a sort of analysis of what is meant. I've had a look at the 2022 Act, and it's quite lengthy and detailed. And I wasn't confident that I perhaps would immediately get the point that IBI are trying to make. So if anyone is prepared to take on that role, that would be useful.
Thank you, Lord. And then the final point they make is that there's an English process on managing derogations and reporting derogations from standards and guidance. And my only point there is, of course, we've heard from NSS that Scotland is already working on a process for this in Scotland, and I have no doubt that NSS will be well aware that there's a process in England, and we'll be looking at that, not necessarily to follow it, but to take it into account. But beyond that, I don't need to say anything more about IBI. So far as multiplex is concerned, the only thing I need to do for the purposes of these submissions is simply to note in passing that multiplex record at paragraph 2.3 that Counsel to Inquiry's statement provides what they describe as a fair summary of the evidence led in respect of the issues of which they have knowledge, and we're grateful to them for that confirmation. Beyond that, they add nothing more, so I need say nothing more either. And that brings me out of the construction group, if I can call it that, into governmental bodies, and I deal first with NSS, and there's much common ground between Counsel to Inquiry and NSS. To take as an example, in paragraph 20 of the submissions that have been lodged by them, they comment on the epidemiological analyses by various parties and suggest that the analyses show a consistent pattern of an increase in bloodstream infections caused by environmental organisms following the move to the new hospital and a subsequent decrease after control measures. That is common ground, and we're obliged to NSS for stressing that that increases confidence in the overall picture with which Lord has been presented. Likewise, in 21, Lord will remember there was a discussion in the evidence of what involvement, if any, NSS had or did not have in relation to the refurbishment process in wards 2A and 2B, which seemed to be at points the subject of some dispute. Paragraph 21 sets that matter out in some detail, and if anything, I suggest points to the value that they could have added to that process had their full offers of assistance been accepted. Maud, they also comment on various proposed recommendations. Now, this may have been covered in our earlier document, but in paragraph 34, there's a proposal to broaden out one of our recommendations, proposed recommendations rather, and we're content with that proposal. That's paragraph 34.
Sorry, Counsel to the Inquiry are content with
what is suggested by NSS, indeed. Now, in paragraph 39, and in particular in subparagraph 1, there is, I think, a suggestion there that other steps could be taken to improve matters involving templates and so forth, but doesn't quite match. There may be some question of people talking past each other. What Counsel to Inquiry have really been focusing on here is ways in which the protection of the public money involved in such a major project can be achieved. And we're not entirely convinced that what NSS propose would achieve that in the way that our recommendation would, but that's ultimately a matter for the Lord. If I just stick with that paragraph for the moment, subparagraph 3, this touches on what we've described as the obligation of cooperation, which Malone will remember in the evidence appears in the NEC3 form of contract, which is the contract form that was adopted in this case and also in other public contracts, we understand. Now, on page 16, NSS say the obligation of cooperation is an NEC contract condition and integral to the ongoing management of the contract. And all we say is, if that is so, and we don't disagree with it, then it would be helpful to have the maximum mutual understanding recorded between the parties as to what that does or does not oblige them to do.
Just seeking to remind myself what Counsel to the Inquiry said on this point that NSS are engaging on. Can you?
I think that this is where we have suggested that there should in effect be some compulsory discussion and resulting protocol on the particular contract as between selected contractor and customer, discussing and agreeing the extent to which that obligation does or does not actually proceed. It's actually require action. It's a topic that is current, Maud. I happened to note just the other day that a leading construction commentator was saying that this is a clause that many parties are actually trying to take out of contracts because they think the uncertainties over what it means leads to litigation, which is a cost they would rather avoid. Just taking that at face value, it does suggest this is an important matter on which discussion and agreement might assist.
How do you define the difference between you and NSS? What I'm reading is looking at the NSS text that circumstances differ and one shouldn't be too prescriptive, but I may be wrong about that.
Well, the position I think adopted in subparagraph 3 is that the specific detail, as appears on page 16, the specific detail of how both parties intend to operate this is typically a project governance matter, fine, which can be set out in the appropriate section of the contract and associated documents as required.
Right.
It may be that not being too prescriptive is what that means, and all that counsel to inquiry are suggesting is that given its potential importance, there should be a mechanism for ensuring discussion and agreement and recording.
Right.
That's all there is to it. In subparagraph 4, there's some comment about different possible forms of contract, but of course, we perhaps understandably didn't comment on any form of contract other than design and build. Other contracts might require different result remedies, and this focuses on this question of having what we've sometimes called a shadow design team, or certainly the availability of expertise. I think my lord may remember that Mr. Winter, when he gave evidence, indicated that when he was in the contracting side, he quite often found that the client turned up with a range of people who kind of matched the advisors that he had. I'm not wanting to be prescriptive about this, but that's the essential point there. So in paragraph 6, Roman 6, page 17, it still is in 39. It says the NSS is concerned about the workability of paragraph 1876C, in particular, the proposed role is beyond the professional capacity of one individual. Now, this may be our fault because our recommendation was that boards should ensure the appointment of a suitably qualified and experienced construction professional during contracts who has the remit to ensure the works meet the employer's requirements or equivalent. Now, if that was worded to suggest it had to be a person, I'm happy to withdraw that. In the contract that is in front of my lord, at least as a possible proposal, the idea was that a firm of experts should provide that service, and I've no difficulty with that concept. But we do maintain the view that someone with that role, some person or group, should be in place. Or if one moves to paragraph 40, which deals with our recommendation in paragraph 1877. This is the one which suggests that there should be government legal advice in and around the contract at key points. Now, this is not supported by NSS. We note all the points they make, and all we say is that given what we say is the ultimate responsibility for a project of this scale, we suggest that something along these lines would be of assistance in protecting the public interest. Precisely how it's done will no doubt depend on any individual case, but we do maintain it's a sensible suggestion. Lord, in paragraph 47, NS suggests that our recommendation in paragraph 1886 should be widened. We're content to record our acceptance of what is suggested by NSS there. In 48, NS has to touch on the possibility that a review might lead to the creation of a regulator or the extension of someone's powers to make them
Sorry, my fault entirely. Which paragraph? were you-
48 of NSS submissions.
Right, okay.
Now, they then say would need to take into account possible unintended consequences, including possible need for further staff. Beyond the need for further staff, I'm not sure what's being referred to here, and it's not necessarily obvious. For instance, if one was to decide that the role of HIS might be reshaped to make them a regulator with compulsory powers. So I simply make the point there's nothing further to assist us on there. And then they make some further comments on which I really needn't comment beyond reminding my lord that we did accept the general proposition that if there is to be someone who might be described as a regulator, because of the cooperative nature of much of the actions of NHS Assure, it shouldn't be that body that should be morphed into a regulator if that was to be done. Beyond that, I have nothing further to add on the position of NSS as set out in their submissions. Now that brings me rapidly to the submissions by Scottish ministers. And if I could just as a matter of note, start by saying this, that in our submission, it is clear that at the full business case stage, Scottish ministers did not know about the ventilation derogation, the change in the maximum temperature, or what we've called the standing down of the technical team, because they hadn't been told about them. So any suggestion to the contrary is not in our submission correct.
Sorry, just from my note,
Yes.
the agreed ventilation derogation.
The change in the maximum temperature variant, as we've called it, and the standing down of the technical team.
Thank you.
Just to start generally on the Scottish Minister's position, because it colours everything else, the thrust of the position adopted by Council to the Inquiry, rightly or wrongly, is to pick up on a comment by the then Minister, Ms. Freeman, which is that there are risks of being too hands-off with boards. And we take from the Scottish Minister's submission that they are quite keen to stay hands-off and to retain the existing, as they would say, demarcation lines. And we seek to persuade your lordship that as the public would see the Scottish ministers as ultimately responsible, they should do more to reflect that. And probably illustrated, my lord, by paragraph 17, or 17 and 20. Here, the ministers refer to the blueprint for good governance that we touched on earlier today. They set out some principles that emerge from that document, and they suggest in paragraph 20 that adoption of these principles should avoid the various issues identified by Council to the Inquiry in various places. And frankly, we disagree. The creation of principles of a general and non-obligatory nature of this kind, we suggest, will not do what is being suggested to ensure effective oversight in an adequate fashion of major infrastructure projects. And that is an unrealistic submission. Understandable, but in our submission, unrealistic. Well, just in passing, we noticed what the minister said in paragraph 24. They remind us that Ms. Freeman had envisaged undertaking a wide-scale review of the culture of NHS, GGC and other health boards, but that really might have been superseded by this inquiry. I'm not sure that's the way the Lord might interpret the terms of reference as a widespread review of the culture of NHS GGC, although obviously a number of cultural issues have been dealt with, and of course it doesn't touch on other health boards. So the question arises whether ministers still intend to follow this through or not. We have no particular view on that, but clearly that's a matter that's in their minds. Ministers also, as with NSS, disagree with the suggestion of them having legal advice, to which we say this. Ministers ultimately are responsible for these things. They fund them, and they're ultimately responsible for the health service. And we argue that if, through legal scrutiny, they were to find a flaw detrimental to the public interest in a contract being entered into by a board, why would it be undesirable or inappropriate to raise this? In fact, they complain of the possibility of conflicting advice, precisely the point, because by definition, in that scenario, the board would not have picked up the point. What's the problem? So, I mean, whether you need to create an additional accountable officer in the shape of the chief executive of the NHS for major projects, I don't know. It doesn't matter. My point is simply that we see this as a helpful suggestion, which might, depending on how it is deployed, assist to avoid some of the issues that we had.
When you use the expression ultimately responsible, do you have in mind the terms of National Health Scotland Act of 1978, which imposes an obligation to provide a health service on, well, originally the Secretary of State and other Scottish ministers, or do you have in mind wider responsibility, such as political responsibility?
I think I see it in two different ways. On one view, one could interpret that statutory provision as laying down ultimate responsibility.
Subject, of course, to
the
delegation.
To delegation. But in addition, the public, we would suggest, see the ministers as responsible for the health service. Whatever niceties might be set out in the Act, and all we're suggesting is that they should take a bit of a more active role in particular respects. The same point probably comes up in one of our more perhaps controversial recommendations, which is focused in particular on what happens if a problem is identified. So if one goes to paragraph 37, the point we're trying to make here is, because we had quite a lot of evidence, Board will recall, about, oh, well, if things crop up, somebody would speak to somebody else and somebody would hold somebody else to account and things would happen. The picture would not be good. All we're suggesting here is, imagine a situation where, after investigation by the NHS, it was decided that a senior officer of a board, needn't be the chief executive, might be another senior officer. Senior officer of a board was responsible for or causing a significant problem about which the board weren't doing anything. At the moment, that person could be removed. If on the board, they could be removed from the board, but their employment would remain in place. And we're purely suggesting that if you say to the public, oh yes, we've taken him off the board, but he's still employed by the health board, drawing whatever salary and benefits are available, and the board aren't doing anything about it, and we can't do anything about it, that seems to me, with suspect, to be a sort of cry of helplessness that the public would find it difficult to understand. If the board do something about it, fine, but then the reserve power wouldn't be required. The one point that we make, just to finish what I say about the ministers, is that there are lots of things that can be done. And we simply raised the question, in light of the context that we have here, about the absence of the word compulsion in many of the areas that we've discussed. Things can be done, people can speak to people, there can be meetings, holding to account, whatever that is, can happen. But there may be a need from time to time for an ability to compel things to happen without dubiety. Well, I have nothing more to say on the Scottish Minister's point, which brings me in order to the submissions by MDDUS. These are lengthy. I don't intend to go through them. In some respects, much of what they say agrees with what Council for the Inquiry have suggested. I tried to find a main message, and in our submissions, my Lord, we suggested at least a degree of caution in deciding whether the change of direction indicated by Professor Gardner can actually be achieved. And in part, of course, that arises from the presence in senior positions of some parties who might be thought to have been the drivers of the previous, now recanted from, line. And if there's one message that I take from the submissions by MDDUS, it is that they agree with that issue of challenge. They do set out, Maud will see when Maud goes through them again in detail, comments on a range of individuals, some still in post, some not. I wouldn't want to be thought to have endorsed all the language deployed about these individuals, but we do commend the Lord to read these passages. And we adopt the same approach, subject to the same caveat, about some of the passages on whistleblowing, which Maud will find starting with para 52 on page 27. Beyond that, my Lord,
Sorry,
I only need...
Just before I
Sorry,
lose
yes.
your point, could you just repeat that? You're adopting what appears in the MDDUS statement in respect of which paragraph?
Well, what I've said is that my Lord will find a series of paragraphs dealing with individuals, which start at page 11 in paragraph 14 and continue for a considerable period of time thereafter, dealing with a whole range of people. All I'm saying is I'm not to be taken to have endorsed every word that's used there, but I do commend these passages as helpful to my Lord to read. And then I'm pointing out that I'm adopting a similar approach about the comments on whistleblowing, which start on page 27 at paragraph 52. So again, not to be taken as adopted every word, but I commend them to my Lord to read. On page 56, there is a suggestion that independent experts should report on various functions on an annual basis for 5 years after the inquiry's recommendations. The suggestions are there should be independent reports on water, ventilation and IPC. Without going into the detail, we're content to endorse the suggestion for water and ventilation, but we hope it's not necessary to do anything similar for IPC. And then finally, in this document, there is an annex which contains ongoing concerns about the state, particularly of Ward 2A. All we wish to say about that is that a lot of these issues could be dealt with by, if it was thought appropriate, a new validation report on the Ward 2A ventilation. And that's what I want to say about MDDUS. Now, that leaves two submissions, well, the one on behalf of the Cudahy and Mackay families and the one on behalf of the group which we're calling Patients and Families. Each of these submissions contain what I'll call, for simplicity, quotations from various participants, setting out their experiences. Speaking personally, reading these as a parent, I confess to finding quite difficult, but perhaps that's the point. They're setting out the impacts of what has happened on them as individuals, and I needn't take my lord through these. The summary that I would take on the Cudahy and Mackay submissions is that the system just didn't work. And on the question of personal responsibility, which my lord and I discussed earlier today, I suggest it's fairly clear on which side of the line the Cudahy and Mackay submissions fall in terms of personal responsibility. In terms of the patients and families submissions, I've made the point about some of the quotations, I won't make that again. On page 4, in paragraph 1.5,
Just give me a moment.
sorry, my lord. Patients and families, page 4, paragraph 1.5.
Yes.
I just want to draw attention to the first sentence there, that the inquiry's remit has not been assisted by what they describe as the belligerent, confrontational and dismissive attitude and tone demonstrated by NHS GDC witnesses. This is again a situation where perhaps the adjectives aren't the ones I would have selected, but I can quite understand why, from the perspective, something along these lines was perceived by those representing those who had encountered the challenges that we've all heard about. Likewise, just picking a reference, another short reference, Maud, because most of it I'm not going to touch on page 52. The foot of page 52, in a series of bullet points, a number of impacts have been selected. And one, my lord will see the first bullet point is the anger that the HAD report was produced late in the day, and from their perspective to seek to undermine the independent inquiry experts, and then they go on to make other comments. So one can understand again that sentiment given what we've heard. Well, almost finished, Lord. Page 54. Another of the bullet points. There's a concern that the inquiry in the hospital are downplaying events in Ward 4B. Well, insofar as that's directed at counsel to the inquiry, we regret if any such impression was given, and that's certainly not our intention to downplay 4B. So it's about it's the fourth bullet point on page 54.
Point being, this is the adult hemato-oncology ward, and there seems now to be accepted that does not meet. I think the question really arises on air change rate.
Yes.
And families are concerned that the inquiry has downplaying that, but you would wish to assure them
that we're not.
that is not your perspective.
That's certainly not our intention. And in fact, we suspect that our persistence with challenges over 4B is a matter of not downplaying, but we have pushed that argument perhaps further than some other participant would have liked. So that would only leave me with 2 points to pick up. In paragraph 10.1, which one finds on page 60, we see there an explanation of the position. I note from the second sentence that at the heart of this suffering lies not only the technical failures of a hospital meant to provide sanctuary and healing, but also a fundamental abdication of responsibility by the Scottish Government. So it's interesting, perhaps what I've been saying just very short time ago about the Scottish ministers, that the patients, families, representatives are also concerned about that issues. They then go on to make various suggestions on which it would be unnecessary for me to comment, but the main point they make there. And the only other one, my lord, is the point that's made on page 74, which is, as we understand it, a suggestion that the inquiry should not come to an end when my lord delivers his report, but should be kept open in an attempt to ensure that various changes which are thought desirable are actually carried into effect. Now, we've looked very carefully at this suggestion. We think that the comparison with the infected blood inquiry is perhaps not a fair one, because in the infected blood inquiry there was much more focus on the role of government rather than, let's say, the role of a board with government as being a secondary player, and also because they had the issue of compensation still to be dealt with at a later stage. So it's not an exact comparison, but we express the hope that there are adequate mechanisms in place for ensuring that any steps that my lord regards as desirable can actually be taken. And having concluded what I have to say about the submissions by the patients and families, these conclude my submissions, with apologies for having overrun the time allocation that I had originally anticipated.
I have prolonged the submission by my questions, Mr. Connell. Can I ask you just to repeat your response to the proposal at page 74
Yes.
of sort of police, if I may, this is not your expression, this is my expression, continuing the inquiry to police
Yes.
the recommendations. Now, the first point you make is that the analogy with the infected blood inquiry is not a complete
Yes.
one. Did you make a second point?
Well, yes, we simply suggest that given everything that has happened from NHS Assure onwards, we hope that it should be possible to convince even the most doubtful reader that there are mechanisms in place and being operated which will ensure that any recommendations my lord makes will be carried through.
Right. Thank you, Mr. Connell. Now, Mr. Gray, I think you indicated that you too wish to make an oral statement, so I would welcome you to the position which we've previously used for witnesses.
Yes, my lord. NHS GGC has previously prepared, as my lord is aware, written closing submissions, which I would formally adopt just now. And my lord, at this juncture, would make a brief supplementary submission on behalf of NHS GGC. My lord, the purpose of the inquiry has been to determine the safety of the water and ventilation systems of the Queen Elizabeth University Hospital and the Royal Hospital for Children, with particular reference to how the systems were designed, built, commissioned, operated, maintained, and tested. Lord, safety has been defined by the inquiry as whether the systems previously presented and now present an avoidable increased risk of infections to patients. My lord, it is submitted that the inquiry can find that the evidence clearly shows that the hospital is now safe. In my submission, the evidence of the inquiry experts is that there is no longer an increased infection rate, and experts are aligned on that conclusion. Rigorous monitoring is in place, and systems have improved, reflected in my submission in the very positive independent audits recently undertaken by Mr. Poplet of the ventilation and water systems, respectively. My lord, NHS GGC has listened to the evidence given at the oral hearing.
Mr. Gray, I needn't tell someone as experienced as you this. If you're reading this, you adopt a reading speed, and your reading speed is faster than my writing speed. So just, could I invite you to bear that in mind?
Indeed, my lord, indeed. I do apologise.
No.
My lord, NHS GGC has listened to the evidence given at the oral hearings and has read all evidence presented in writing. My lord, as has been stated in evidence on a number of occasions in this inquiry, NHS GGC is the largest health board in Scotland, providing a vital public service to in excess of 1 million people. My lord, as an organisation, it takes the onerous responsibilities which it owes to its patients extremely seriously. And against that background, it is a matter of the greatest regret and concern, in equal measure, that in relation to many of the issues with which the inquiry has been concerned, it has been clear from the evidence led that there have been significant failures on the part of NHS GGC. And my lord, these failings are acknowledged and accepted. Lord, as was stated in the written submission, it is a matter of profound regret that those who NHS GGC care for have experienced distress, anguish, and suffering as a result of these events. And NHS GGC offers a full and unreserved apology for the distress and trauma experienced by patients and families during this time.
Right. Having got that, a full and unreserved apology for the pain and trauma experienced at this time.
Indeed, a full and unreserved apology for the distress and trauma experienced by patients and families during this time.
Distress. So it's an apology for an outcome.
It is an unreserved apology, my lord, for the failings which have been unequivocally acknowledged by NHS GGC, and for the distress and trauma which those failings and consequential events have caused to patients and families. My Lord, NHS GGC has taken steps to foster a culture where clinicians and staff should feel confident to report concerns. And that those concerns will be acted upon, and that they will be supported throughout the process. My Lord, these improvements are ongoing, and Professor Gardner gave evidence of the steps that have been taken and the steps that will be taken in future. My Lord, NHS GGC has listened to the evidence of the expert panel. And whilst no definite link between any infection and any confirmed source of infection was ever established.
Sorry, give me that again. When you're talking about the expert
Yes,
panel,
Lord.
you mean the, I don't think we ever formally designated them as a panel, but you mean Dr. Mumford and her colleagues?
Indeed, my Lord.
Yeah. Sorry, I interrupted.
My Lord, whilst no definite link between any infection and any confirmed source of infection was ever established, the experts all agree, including the HAD experts, my Lord, that on the balance of probabilities, there was an infection spike apparent during the water incident.
Now, when you use it, perhaps I should get the formulation first. While no definite link ever established, the experts were agreed, including Professor Hawkey and Dr. Drumright and
Dr.
Agrawal, that there was an infection spike. And
Indeed,
I
Lord.
then interrupted you.
That there was an infection spike apparent during the water incident. And my Lord, NHS GGC accepts that there was, on the balance of probabilities, an increased risk of infection during that period. And that is acknowledged in the written submission, that on the balance of probabilities, there is a causal connection between some infections suffered by patients and the hospital environment, and in particular the water system.
Right, have you finished the formulation? Because I think I have questions arising out of it.
Perhaps I could just finish by saying, my Lord, that experts agree that there is no longer an increased infection rate, and that in my submission further supports the conclusion that the hospital is safe.
Right. When you use the expression no definite link ever established, could you tease that out for me, please?
Yes, my Lord. all that the point I'm seeking to make is that, as my Lord will recall, direction one in relation to this public inquiry was that any findings would be made on the standard being on the balance of probabilities, and that in the course of the evidence that was led before the inquiry, there was in fact no evidence established that there was a definite link.
Well, it's the expression definite link that I want your help with.
Greater than on the balance of probabilities.
Right.
And of course, counsel to the inquiry's closing submission is that my Lord should find that on the balance of probabilities, there was a causal connection between some infections and the water system, and that is entirely accepted, my Lord. And the importance, having regard to what my submission has been misreporting by the media of NHS GGC's written submission, is that it is important to highlight that the admission made by NHS GGC is on the balance of probabilities. That reflects entirely the position taken by the counsel to the inquiry, and that the inquiry is not concerned with whether there was any definite link or not, but as a matter of fact, no evidence was led to that effect.
And that's consistent with the findings of the case note review in respect of the 86
Yes, Lord.
cases. Now, you say there was an infection spike apparent during the water incident. Now, would I be right in identifying the water incident as a reference to the IMT, which was established in March 2018?
Yes, Lord.
And I don't think was closed until the end of 2019. Is this a convenient moment to take for me to take you to your closing statement?
Yes, Lord.
Now, can we go to paragraph 4.2? Now,
Yes,
what you've just said, Mr. Gray, is that there was an infection spike apparent during the period March 2018 to the end of 2019. Now, it appeared to me that what you're saying in paragraph 4.2 is there was an exceedance in the rate of environmentally relevant bloodstream infections, which might be a more formal way of describing a spike, among the pediatric hemato-oncology patients in the RHC in the period 2016 to 2020, which, as I recollect, would be consistent with evidence we heard.
Indeed, Lord.
Right, so is the period of exceedance 2016 to 2020, which of course includes but extends beyond the water incident.
Indeed, Lord.
Right.
And it is, I don't depart at all, my Lord, from what is set out in paragraph 4.2, that it is accepted that there was an exceedance in the rate of environmentally relevant bloodstream infections amongst pediatric hemato-oncology patients in the RHC in the period 2016 to 2020. And the only point which I seek to make by talking about the period of 2016 to 2018 is that the evidence showed that whilst there continued to be an exceedance after 2018, it did begin to decline as a result of the various measures taken, including those to the water system by way of chlorine dioxide dosing.
Right, you anticipate my taking you to 4.3, because the position, just so I'm absolutely clear, the position of GGC is there was an exceedance of infections in the period 2016 to 2020.
Yes, Lord.
However, from a date after the end of 2018, associated perhaps with the chlorination of the water, that rate of exceedance declined. GGC accepts that there's a causal relationship between that exceedance and the state of the water system.
Entirely wrong.
Now, could I just, while we're at this sentence, look at the first sentence of paragraph 4.3. You begin by saying it's broadly acknowledged there's no definite link, and we've talked about that. GGC accepts, having regard to the evidence led, that it is more likely than not that a material proportion of the additional environmental relevant bloodstream infections had a connection to the state of the hospital water system. Now, why do we see the words material proportion?
My Lord, that's simply adopting the words used by counsel to the inquiry in the question that was asked in their closing submission, to my recollection.
I don't think it is, because you've accepted additional incidents.
Yes, Lord.
You've accepted a causal connection. Why do we find the expression material proportion?
Lord, as I say, Lord, my recollection is that that was the terms used in the questions posed by counsel to the inquiry. But really, to reassure my Lord, I draw any between some infections and the material proportion.
Right. Can I strike out material proportion?
Yes, Lord.
We'll check in the formulation, but I take it that GGC have taken their own view of the evidence.
Yes, Lord.
Right.
But it coincides with that of counsel to the inquiry, because in my submission, whilst the positions of experts instructed not aligned at the outset, by the time the evidence of all experts had been concluded, there was in my submission a concurrence of views that there had been an exceedance during the period which I have described, which on the balance of probabilities was causally connected in relation to some infections to the water system.
Would I be right in thinking that almost as soon as Professor Hawkey was sitting where you were sitting, he didn't contest that proposition?
No, he didn't, Lord.
No. And Dr. Drumright confirmed it.
Indeed. But as my Lord will recall from the first report provided on behalf of by Dr. Agrawal, Drumright, and Professor Hawkey, that was not their position. And following the iterative process of exchange of reports and supplementary reports being provided, there was that consensus.
Now, I interrupted you, Mr. Gray. The last note I have is the agreement of experts.
Thank you, Lord. My Lord, it should be emphasised in my submission that what is accepted following the conclusion of the expert evidence is the probability of a link between the hospital environment and some infections, as my Lord and I have just discussed. It is no more specific than that. The inquiry has not explored the question of any link between the hospital environment and any individual patient.
That would have been beyond its terms of reference.
Indeed, my Lord. No evidence was led to demonstrate any link between the hospital environment and any individual patient. The inquiry's remit and terms of reference, as my Lord has just observed, did not extend to consideration of a link between the hospital environment and a link to infection in any particular or individual case.
I would accept that, but I would also understand that the GDC accepts the conclusions of the CNR report, which were directed at individual cases.
Indeed, Lord. Lord, media coverage of NHS GDC's submissions in recent days has portrayed wrongly in my submission that NHS GGC accepts a link between the hospital environment and infections in certain individual cases of infection. That is not the case, and it is important in my submission that this point is emphasised, lest there be any doubt or misunderstanding on the matter.
Sorry, it's my fault. I agree with you that the inquiry has not looked at individual cases. The case notes review did look at individual cases and came to the conclusions which are published in its report of March 2021. As I understand it, GDC accepts these conclusions.
Accepts that the conclusion that there were a causal connection between some infections and the water system. As my Lord is aware, the case note review has looked at particular cases of infection and has reached conclusions in relation to them specifically, none of which have been published or of which NHS GGC has any knowledge. Therefore, what NHS GGC accepts is what is essentially, as I understand, not contentious within this inquiry, that there was, on the basis of the expert evidence available, evidence that on the balance of probabilities, my Lord could find that there was a causal connection between some infections and the water system, and that the use to which one could have regard to the case note review was, as counsel to the inquiry put it in their closing submission, by way of a cross-check to confirm or otherwise the view that had been reached on the basis of the expert evidence led. But in terms of accepting the case note review, inevitably, NHS GGC is not able to do more than to accept that there was, on the balance of probabilities, as found by the case note review, a causal connection between infection suffered by some patients and the water system. And that is precisely the conclusion advanced by counsel to the inquiry. My Lord, if I may move on unless my Lord's got further questions at this juncture. My Lord, I was making certain submissions about media coverage and would simply just pick up from where it left off, that media coverage of NHS GGC submissions in recent days has portrayed wrongly that NHS GGC accepts a link between the hospital environment and infections in certain individual cases of infection, as I just indicated to my lord. That is not the case, and it is important that this point is emphasised, lest there be any doubt or misunderstanding on the matter. It will be clear in my submission that inaccurate media reporting on such important and sensitive matters will inevitably result in distress to patients, families, staff, and all who use the services provided by the Queen Elizabeth University Hospital and the Royal Hospital for Children.
My fault entirely, Mr. Gray. I'm being somewhat pedestrian here. What I want at dictation speed is what you say has been wrongly reported.
Lord. Media coverage of NHS GGC submissions in recent days has, in my submission, portrayed wrongly that NHS GGC accepts a link between the hospital environment and infections in certain individual specified cases of infection. And that is the principal respect in which it is submitted that there has been misreporting, and that has had, in my submission, very unfortunate consequences. And because of that, it is important that the point is emphasised that no such admission was made of that specific nature. And the reason in my submission that it is important to make the position clear is that inaccurate media reporting on such important and sensitive matters will inevitably, in my submission, result in distress to patients, families, staff, and all those who use the services provided by the Queen Elizabeth University Hospital and the Royal Hospital for Children. And the impact of such distress from misreporting by the media, particularly upon patients, families, and those who have lost loved ones, cannot, in my submission, be overstated. My Lord, in my submission, the inquiry can have confidence that NHS GGC is a very different organisation to the one that was involved in the design, build, construction, and validation of the hospital.
Matter of small detail, has the hospital building been validated in any respect?
had it, or
Has it at any time in its history since handover?
I would need to take instructions on that matter, my lord, but I would be very surprised if it has not, because the failings with which this inquiry is concerned and which have been accepted by NHS GGC have been addressed comprehensively in my submission. In particular, those in relation to defects in the water system and ventilation system. But it is a matter upon which, if I may, I will take specific instructions, Lord.
It may or may not be important, Mr. Gray, but the point you're making at the moment is not about validation. The point you're making at the moment is about an organization. However, in giving me a time frame to compare organizations, you ran through a period beginning with design, going through construction, and in the way you put it, ended with validation. Now, we've heard evidence that validation has a particular meaning in a construction contract. The only evidence as to whether validation is required, and I use that in a very loose way, comes in relation to ventilation. But the reason I picked you up was it was your expression, and I took it that by using it, you related it to something that had happened. I don't think we've heard any evidence of validation in the sense that we've had evidence about. In other words, the client satisfies himself by means of an independent, appropriate person that he's got what he wanted. That is my only point, but I appreciate that you are making a different point at this stage.
Yes, and the point that I am making, my lord, is that if one looks at that period of time and one looks at NHS GGC now, in my submission, they are very different organisations in terms of the approach and their attitude to ensuring that the failings with which this inquiry are concerned have been addressed. I would also submit that this is a different organisation to the one that was faced with the incidences of infection that the inquiry has considered. It is, however, as Professor Gardner made clear in her evidence, an organisation which is continuing to learn. Professor Gardner was, in my submission, in no way complacent about the position, and that it is an organisation which continues to learn. And the evidence presented to the inquiry has informed that learning process for NHS GGC. And if my lord makes the recommendations which he is invited to make by counsel to the inquiry, then those recommendations will inform further improvement. Now, in relation to recommendations, NHS GGC, as my lord is aware from the written submission, has proposed its own recommendations to the chair. And those recommendations are aimed at enhancing national reporting of infection so that hospitals in the NHS Scotland estate all report infections in the same way, allowing for better monitoring. And the proposed recommendations are also aimed at ensuring colleagues who wish to raise issues, whether formal whistleblowing or otherwise, are listened to and supported. And my Lord, on behalf of NHS GGC, as was stated in the written submission, I would wish to repeat that it offers to my Lord its full assurance that it will take forward any and all recommendations which may be addressed to it in due course by my Lord to the fullest extent possible. Lord, if I may turn now to the question of the manner in which the NHS GGC has changed. Lord, in my submission, whether a hospital is safe or unsafe requires to be looked at holistically, and that includes culture. Lord, if there is not a culture that allows colleagues to raise concerns, be listened to, and for them to be assured that their concerns will be acted upon, there is a very real risk that they will not raise those concerns at all. Lord, if those at the forefront of patient treatment cannot raise concerns, obviously those concerns cannot be acted upon. And my Lord, in this regard, the inquiry heard evidence from Professor Gardner, and in my submission, her evidence was forthright. She accepted unequivocally failings in culture. She explained that those failings were being acted upon and that they would continue to be acted upon. My Lord, core participants express a degree of scepticism in my submission of Professor Gardner's evidence. In short, they question why they should believe what she is saying. The answer to that in my submission is that Professor Gardner has not attempted to hide failings. She does not suggest that the failings have been fixed. She explains that work has been done and that work will continue to be done. And as I submitted earlier, my Lord, she does not show any complacency. And Professor Gardner does not suggest that NHS GGC should wait for the outcome of this inquiry and the Chair's recommendations. She is, in my submission, ensuring that proactive steps are being taken. In short, in my submission, Professor Gardner demonstrates many of the key qualities of leadership which are seen to be crucial to effect cultural change. Those qualities of leadership having been identified by both Sir Robert Francis and Mr. Malcolm Wright in their evidence on the subject of effective cultural change when giving evidence to the inquiry. My Lord, in her evidence, Professor Gardner apologised to the whistleblowers for the distress they experienced.
Well, did she?
My Lord, I would invite my Lord to read Professor Gardner's evidence in full and to form his own view as to the manner in which her evidence was given, the tenor of that evidence, the sincerity of that evidence, and when looked at as a whole, in my submission, an apology and a proper and appropriate apology was made by Professor Gardner. But it is a matter for my Lord as to the impression which she formed from her evidence and the way she gave it.
I thought it appropriate to reread the transcript of Professor Gardner's evidence last week. A transcript, I mean, I have a recollection of the way in which she gave her evidence, and I make no observation for critical nature. But I think she only uses apology in the context of, understandably, not being able to apologize on behalf of the board. That's entirely understandable. And as I said to Mr. Connell this morning, for someone who only comes into post in February of last year, she might have nothing personally to apologize for. But I did not. I mean, I thought it worthwhile noting what the transcript indicates that she said. And at column 159 on the transcript for the 9th of October, I am sorry that individuals did not feel listened to by the organization and were not treated in a way that allowed them to feel empowered and to be able to be harnessed into a solution, and were not afforded that opportunity. Now, I don't say that's an inappropriate form of words. I'm not questioning that Professor Gardner is a sincere person with excellent ambitions for GGC. I merely make the point that on my reading of the transcript, and I'll be corrected, I do not find an apology to the microbiologists who brought forward concerns.
There is in my submission an apology that was made for the distress that they experienced in general terms, as my Lord has provided from reading from the transcript. And that apology, which was adopted fully and unreservedly in the written submission on behalf of NHS GGC, is repeated today. And in particular, my Lord, it is acknowledged that whistleblowers were not treated in a manner that allowed their concerns to be fully listened to and acted upon. That was, it would appear, against a background of an unprecedented situation of significant complexity, at a time when there were clearly tensions amongst all staff about how that situation should be handled. That, however, my Lord, I entirely accept is not an excuse. The manner in which whistleblowers were treated was not acceptable, and I would invite my Lord to accept from the evidence of Professor Gardner that it would not happen now. Now, where any colleague wishes to raise concerns, the evidence of Professor Gardner, my submission was clear. They will be listened to and will be made, if they wish, to be part of the resolution. And in respect of term of reference 4, my Lord, in my submission, contrary to the position before, the culture now encourages reporting of concerns. Lord, as was submitted in the written submission, 2025 marked the beginning of a new chapter for NHS GGC with new leadership. A new structure is in place, as spoken to by Professor Gardner, and NHS GGC is dedicated to providing the best care possible for its patients and to fully supporting its staff to enable it to provide this care. Lord, to repeat what is said in NHS GGC's closing submission, staff and clinicians should feel assured that if there is an issue that they identify, that they will be listened to. Equally, patients and families should feel assured that NHS GGC is fully supportive of its clinicians and staff. and external agencies should be assured that incidents will be reported with full cooperation and transparency. Lord, NHS GGC repeats that in a number of respects, its management of the issues investigated by the inquiry fell well below what patients, families, clinicians and staff should expect.
My, my fault, Mr. Gray. GGC repeats in a number of respects, and I just fell behind.
I apologise again, my Lord.
No, I'm not fast enough.
Lord, that the NHS GGC's management of the issues investigated by the inquiry fell well below what patients, families, clinicians and staff should expect. My Lord, whilst those failings are acknowledged in full, it is submitted on behalf of NHS GGC that all of its staff and clinicians at all times did what they considered was best for patients, acting in good faith. The evidence shows that they were dealing with an unprecedented situation. There was, as I indicated earlier, significant stress put on individuals and systems. The systems in place were tested beyond breaking point, and those tensions were not managed. In this regard, too, it is submitted that lessons have been learned. My Lord, it is submitted that the evidence led before the inquiry does not support that any individual put self-interest or organisational interest before patient safety. It is also submitted that the evidence does not support that there was a cover-up.
With apologies for interrupting, cover-up is not a word that we find in the terms of reference.
No, I think, my Lord, it may have been a term used by some witnesses. I may be wrong in my recollection, but that is my recollection.
I mean, it has a certain history, I suppose, but it's not a term that I can address directly. What I can address is the language of the terms of reference. which I think the relevant provision is term 4. Deliberately concealed or failed to disclose evidence of wrongdoing or failures in performance or inadequacies of systems. Whether cover-up is a useful substitute for the terms of reference, I'm not sure.
But no doubt, in considering all matters relevant to the terms of reference, my Lord will consider the evidence given by witnesses and their credibility and reliability. It may be in that context that my Lord would consider the submission which I make, but it is a matter for my Lord. It is important, nevertheless, in my submission for the submission to be made that at no point in my submission was there any cover-up.
And does that comprehend failures to disclose failures in performance or inadequacies in systems?
Yes, Lord. In terms of any cover-up of those inadequacies, it is submitted there was no such cover-up.
Well, I don't want to detain you over long and be more pedestrian than is necessary, but the expression cover-up might be an informal way of describing deliberate concealment, but cover-up to me is something different than a failure to disclose.
Absolutely, I entirely agree, Lord.
Yeah. So it may be that you're just concentrating at the moment on deliberate concealment.
Indeed, Lord.
Right. Sorry for being so slow.
No, not at all, Lord. And a failure to disclose could be entirely inadvertent. What has been stated in evidence, my recollection, is that in some respects, employees of NHS GGC or as the organisation as a whole engaged in what I recall was described as a cover-up, and that is not accepted. Lord, failures in communication are acknowledged. It is also acknowledged that those communication failures led to increased anxiety for patients and families. But that, in my submission, does not support the finding that any individual deliberately concealed something for the purpose of self or organisational interest. As alluded to be considered under term of reference 4. My Lord, NHS GGC did not get the hospital it asked for. When the hospital opened, it is clear from the evidence that there was significant work ongoing, with many contractors still on site. Court action is ongoing against Multiplex and others.
As a matter of minor detail, I think the inquiry is aware of the Court of Session action that was, I think, served in January of 2020. My recollection is that there are 4 defenders in that action, Multiplex and 3 others. I wasn't clear from the closing statement whether there are other litigations ongoing.
There are indeed, my Lord, and I think my Lord would allow me just one moment to.
Surely, yes. It's a matter of small detail, but it's just to understand what was being said in the closing statement.
I think from recollection there are 3 additional actions which are ongoing, my Lord. Yes, my Lord, the main action, as my Lord has indicated, was raised by NHS GGC in the course of session against Multiplex, their parent company, and Curry and Brown. And as I indicated to my Lord, 4 additional actions were raised by NHS GGC, 3 against Multiplex and their parent company, and 1 against Curry and Brown in respect of separate issues pertaining to the Queen Elizabeth and RHC bill.
I don't want to take you away into detail. The 3 additional actions and the 1 action, does that deal with cladding or maybe deals with a number of issues?
I'm afraid I would need to take instructions on that, my Lord. I'm not familiar.
I'm taking up your time, Mr. Gray. Please, we can perhaps explore that otherwise.
Yes, my Lord. Lord, it is submitted, however, that the inquiry is not the appropriate forum to consider any claim against Multiplex. Remedial work has been carried out to address issues with the building, and steps have been taken to ensure that colleagues are fully trained and have the necessary expertise such that the built environment can be managed so that it is entirely safe for patients. My Lord, turning, if I may, to some very brief submissions about in relation to infection risk. As I indicated earlier, my Lord, NHS GGC accepts that the expert evidence shows on the balance of probabilities that there was an increase in infections, and experts are aligned on that conclusion. And NHS GGC has worked continuously to improve the hospital infrastructure to the extent that it now presents a safe environment for the delivery of care for all patients. My Lord, in my submission in respect of water, the expert's evidence supports that the system is now managed to the point that it is undoubtedly safe. That includes monitoring, filtration and dosing, and it also includes, importantly, ensuring that those with appropriate expertise are responsible for the system and are fully trained on it. And it is submitted that the inquiry should make a finding to the effect that the system is now safe. My Lord, it is accepted that the ventilation system does not meet the standard in SHTM 0301. However, the Lord has recognised in the interim report that infection control is multifactorial Monitoring of air quality is in place and steps are taken to manage risk. And again, it is submitted that the inquiry should make a finding that the system is accordingly safe.
Consistent with what you said, I think, very early in your submission, if I'm to accede to your invitation to express any views on the word safe, I would have to have regard to the culture of the responsible organization.
Indeed, my Lord.
I mean, it's not simply a question of measuring air quality.
I entirely accept that,
Right.
my Lord. My Lord, in relation to the management of infection risk, infections must be reported to ensure that overall risk is properly monitored, and standardized reporting and strengthening national surveillance that is submitted will assist with this monitoring. And that is the basis for NHS GGC's suggested recommendations as to national monitoring. Lord, in conclusion, NHS GGC wishes to repeat that patients and their families are at the centre of everything that NHS GGC does. The same is true of staff. It is submitted that the situation faced by NHS GGC was unprecedented. But failings are acknowledged in full, and an unreserved apology is repeated. NHS GGC, my Lord, in my submission, is a different organisation to the one it was. It is continuing to learn and improve. And as I indicated to my Lord earlier, this inquiry is a vitally important part of that process. My Lord, patients and families can have confidence in the built environment and should be assured that they will experience high quality, specialist and expert care from committed expert clinicians in a hospital which is safe. My Lord, in her report to the inquiry on the subject of risk management, Dr. Mumford concluded, and I quote, that no healthcare organisation is without risk. In order to determine whether the hospital is now safe for patients, the management of risk within the organisation should be examined. The risk management must be robust, with active management and monitoring of the water and ventilation systems. And monitoring of infection rates responsive to any anomalous findings. And more crucially, responsive to concerns raised at all levels, from ward to board, with a learning and just culture.
I can go to the report, but crucially responsive
To concerns raised at all levels, from ward to board, with a learning and just culture. It is submitted, Lord, that the steps recommended by Dr. Mumford are precisely those which have been taken by NHS GGC and which continue to be taken. And which continue to be taken, my Lord, in its commitment to safety. The success of which is reflected in my submission in the very positive independent audits to which I have referred of the water and ventilation systems, respectively. My Lord, that commitment to safety will continue assisted by the recommendations or proposed recommendations which NHS GGC endorses fully, and the proposed independent scrutiny of its actions going forward, which it welcomes.
I just revisit the last sentence.
Yes, Lord.
That commitment to safety will continue, and then you made some reference to recommendations.
Yes.
Now, which recommendations were you referring to?
All the recommendations that are proposed by Council to the inquiry, Lord. Just for my Lord's note, it may assist if I just read the last sentence again. That,
Surely.
That commitment to safety will continue, assisted by the recommendations or proposed recommendations which NHS GGC endorses fully, and the proposed independent scrutiny of its actions going forward, which it welcomes. And those, my Lord, are the submissions which I make at this stage.
Now, I have some questions for you, Mr. Gray. I appreciate we allocated this afternoon for your contribution. I don't see our timetabling as essentially compromised, but what I would propose to do is sit until 4:30. First of all, does that cause you any difficulty?
None at all, my Lord.
As I say, I propose we will sit until 4:30, not beyond 4:30, but I appreciate there may be those in the room who've made their plans on the basis of a 4:30 finish, and therefore, if anyone wishes to leave, I would fully understand. But as I say, there's maybe one or two questions I would
Indeed, my Lord.
value your assistance on, Mr. Gray. No. Now, can I begin by settling in my mind the evolution of GGC's position? Because I think you point out in your closing statement that, having had regard to the evidence heard, GGC's position has evolved. Now, GGC previously submitted a number of closing statements. And if I'm correct, the first closing statement was following the hearings in 2021 and is dated 15th of December 2021. The second submission followed the June 2023 Glasgow QEUH hearings, and that closing statement or submission appended two positioning papers which had been previously provided. One dated the 14th of December of 2022, and the second dated the 5th of April 2023. After the Glasgow 3 hearings towards the end of 2024, you submitted a closing statement dated the 31st of January 2025. Now, there then followed a procedural hearing on the 11th of March of 2025, during which was planning for the Glasgow 4 hearings. And I took the opportunity to draw your attention to the terms of Inquiry Direction 9 and suggested to you that the closing statement of January 2025 had not dealt with specific facts, and you were gracious enough to agree with me on that. And as a result, you provided a response to the Direction 5 request, and I have to stress that my powers are limited to request, on the 26th of June of 2025. Now, I think it would be fair to say that that remained a fairly high-level document.
Yes, Mark.
And then on the 23rd of December of 2025, following the three parts of the Glasgow 4 hearings, you have provided us with your most recent closing statement. Now, you explain at paragraph 1.4 of your most recent closing statement that the submissions contained in it supersede all positioning papers and all previous submissions on the evidence. Am I right?
Yes, Lord, I can confirm that paragraph 1.3 of the final submission supersedes paragraph 21 of the submission following Glasgow 3 in relation to the assessment of the evidence. Lord, the submission as regards unwarranted criticism of witnesses and the manner in which they gave evidence is maintained, Lord.
Sorry, give me that again. What is maintained?
Lord, the submission as regards unwarranted criticism of witnesses and the manner in which they gave evidence is maintained. So that was a submission made following the Glasgow 3 hearing. Beyond that, counsel to the inquiry's assessment of the evidence is entirely accepted.
Right. Can I just make sure we're looking at the same documents? In relation to what is maintained, which of your closing statements would you wish me to look at? The Glasgow 3 one?
Yes, my lord, in which criticisms were made of, in certain respects, the approach that had been taken by counsel to the inquiry in relation to witnesses and the manner in which they gave evidence. And the criticisms that were made were set out between paragraphs 16 and 21 of the submission following Glasgow 3. So that, my lord, is prior to my lord's invitation to me to provide further supplementary submissions.
Right. So you maintain the as far as counsel to the inquiry's assessment of evidence, you accept that.
Yes, Lord.
And in referring to the assessment of evidence, that's the assessment of evidence in the council's submission after Glasgow 4, and I assume also after Glasgow 3.
Indeed, Lord.
Right. However, you maintain the position in paragraph 16 and 21 of the closing statement after Glasgow 3, which includes a submission that counsel to the inquiry has adopted a plainly partisan and adversarial approach.
Yes, Lord.
And their evidence is subject to unjustified criticism.
Indeed, my lord. And the criticism, my lord, is not withdrawn. It is one which was made on the basis of the impression which was formed by counsel to the inquiry's approach to certain witnesses.
And what were the features of the approach which led to your criticism?
My Lord, that in the approach taken, counsel to the inquiry had adopted what in our submission was a plainly partisan and adversarial approach, which appeared to advance the interests of certain individuals to the detriment of NHS GGC, and more importantly, the public interest.
Now, who were the individuals whose interests were being advanced?
It would have appeared to have been the interests of whistleblowers, my Lord. Now, my Lord, that impression was one which was based on one's professional judgment and experience. I entirely accept that it may not have been counsel to the inquiry's intention to adopt such an approach, or indeed to give such an impression. But that was the impression which was created, and it was most unfortunate.
Sorry.
I was just going to conclude that, my Lord, by saying that I accept immediately that such impressions are entirely subjective, and it is ultimately a matter for my Lord to determine as to whether the criticism is found to be valid or not.
Well, I would have been assisted in that, Mr. Gray, had you raised the point at the time, which I can't recollect you having done.
I did not raise the point at the time, my Lord. As my Lord will appreciate, we are in an inquiry. This is not an adversarial process, and it is my Lord's inquiry. And I have no doubt that if my Lord had considered that the approach being taken was inappropriate, that my Lord would have taken such action as he considered appropriate. And added to that, in some respects, my Lord, the impression of counsel to the inquiry's approach having been as I described, and really to some extent crystallized when one saw the terms of the written submission following evidence as well. But my Lord is entirely correct in his recollection. No objection was made, and it was not made for the reasons which I have given.
And I take a step back to talk in a general way about safety. Now, as you have correctly said, at the stage of Glasgow 3, the question used to explore the notion of safety was avoidable risk. In Glasgow 4, one might see a different approach associated with risk assessment and risk management. Now, the Scottish Government has produced a number of policy documents. There are acts of the Scottish Parliament. I have in mind the Patients' Rights Scotland Act of 2011, the NHS Scotland Quality Strategy. That's a policy document. The statutes which I have in mind are the Patients' Rights Scotland Act 2011 and the Patient Safety Commissioner for Scotland Act 2023. Now, what one might see in these policy documents, standards, and statutes are the aspirations that government is putting forward in respect of safety in hospitals. Now, it occurs to me that one should have regard to these before making any statement about safety in hospitals. Do you have comment on that?
Yes, if the Lord has in mind that the terms of reference require the inquiry to determine whether the hospital buildings provide a suitable environment for the delivery of safe, effective, person-centred care, and whether any of those statutes or guidance may be relevant to the consideration of what essentially is meant by the phrase safe, effective, person-centred care. In my submission, what may constitute a suitable environment for delivery of safe, effective, patient-centred care must inevitably be multifactorial and would embrace not just the physical environment, but also a whole range of other issues that have been discussed by witnesses and evidence, including the competency of staff, the governance of the hospital, the existence of an appropriate culture, and so on. And if I am correct that the environment is multifactorial in the way I've described it, then in my submission it's very likely that all the documents and guidance to which my Lord has referred would have some relevance and provide some assistance in determining that question.
I mean, it occurs to me that in part, safety is about an aspiration, and it's in part at least about what a society is trying to achieve as expressed in policy and statute.
Yes, Lord.
Right. I think we've seen reference in the closing statements to the report of the Vale of Leman inquiry. Do you have any comment on the utility of referring to that?
It is clearly an inquiry which explored issues of failings in a hospital environment, and the Lord may find assistance in having regard to its terms, but I have no particular submission to make about it, my Lord. And of course, I think perhaps only passing reference has been made to it in evidence, but that wouldn't prevent my Lord having regard to it if my Lord found it of assistance.
Precisely. I think you're right in saying that hardly any reference is made, and this would apply to other inquiries such as the infected blood inquiry. But would I nevertheless be entitled to look at these
Definitely.
reports. I have other questions, Mr. Gray, but it's now 4:30, and I said I wouldn't sit beyond 4:30. We will convene again, and can I ask you to be back tomorrow for 10 o'clock?
Yes, of course, Mark.
Thank you.
Thanks, Dan.